Chapter 9 Introduction to Contract Law. Classic Case. In this case, the court considered whether Miller, the plaintiff, was entitled to a commission for helping Stevens sell his dyeing business. Miller and Stevens did not have a written agreement that Miller would provide this service. If there was an agreement, it would be implied by this situation. The court also considered whether any agreement would be illegal and prevent Miller's recovery. Miller v. Stevens. Facts. Miller's business was selling coal. In the winter of 1920 through 21, Miller and George Stevens boarded at the same hotel where they became hotel acquaintances. During their casual talks, Miller learned that Stevens owned a dyeing business known as the Parisian Dye House. Stevens was considering selling the business because he could not give it proper attention. The next summer, while Miller was trying to sell some coal to M. Deebs, he found out that Deebs was interested in starting a cleaning and dyeing plant. Recalling what Stevens had said about his dye house, Miller phoned Stevens to see if Stevens still wanted to sell his dye house and if Miller should send Deebs to see him. Stevens indicated that he was willing to sell, and Miller brought the parties together. Negotiations resulted in the sale of the dye house to Deebs for $6,000. Prior to this time, Miller had never acted as an agent or broker, in buying, selling, exchanging, or offering for sale any business for others. Miller never advertised or held himself out as an engaged in such business. As a circuit court, Miller recovered a judgment of $300 for his services in getting Deebs to buy the business. Issue. Is Miller entitled to compensation based on an implied in-fact contract? Holding yes. Miller is entitled to the compensation awarded by the lower court. And reasoning. Excerpts by the opinion of Steer J. The court also considered whether Miller violated a state statute making it unlawful for a person to engage in the business of a business chance broker without first obtaining a license. The statute created and defined the title business chance broker. The proofs are that the plaintiff had never directly or indirectly offered or rendered services for others of the kind covered by the Act prior to this. The question of his guilt turns on the one transaction. If his services on that occasion classify him as a business chance broker, he could not recover under prevailing authorities. Such statutes do not ordinarily apply to the case of a private individual not carrying on the business of a broker, and such a person may recover an agreed commission for a single sale, though he had no license. Plaintiff's regular business was selling coal on commission. The courts have generally held that a single sale or act of a private citizen in relation to a vocation prohibited by statute without a license is not, standing alone, carrying on the forbidden business. Plaintiff's participation as an intermediary in negotiations for the deal involved here was not such an engaging in the business of a business chance broker, as would under the statutory definition preclude to his recovery for the services rendered. Plaintiff's claim is based on an implied contract. He admits he had made no claim for compensation until after the services were rendered. A contract is implied where the intention as to it is not manifested by direct or explicit words between the parties, but it is to be gathered by implication or proper deduction from the contract of the parties, language used or things done by them, or other pertinent circumstances. Where there is no express contract, a contract may be implied in fact where one engages or accepts beneficial services of another for which compensation is customarily made and naturally anticipated. And although there are no express stipulation between the parties for wages or price, the law implies an understanding or intent to pay the value of the services rendered. Defendant contends that the services were gratuitous and compensation an afterthought of plaintiff because no mention of compensation was made by him when his services were offered. Accepted and rendered, and his first bill for pay was rendered to M. Deebs and George Stevens for sale of dye plant. $6,000 cash, 5%, $300. Plaintiff testifies that he expected compensation for his services, which were rendered for defendant, accepted by him, and continued during the negotiations at his request, that when the parties were closing the deal, he heard Deebs say, "Miller will want $500 out of this," that while he represented Stevens, he did not at first know who was to pay. and he learned that in those transactions the seller pays the commission. Plaintiffs rendering a joint bill for his services to both Deebs and Stevens was a proper matter for the jury to consider. We cannot say as a matter of law it precluded the court from submitting the issue of an implied contract to the jury. Plaintiff's testimony is positive that Stevens replied affirmatively to his inquiry as to whether he wanted to sell his dye house and accepted his offer to send Deebs to him, which opened the negotiations, and during their continuance he represented Stevens, did various things to help the deal along. Plaintiff's testimony raised an issue of fact for the jury. The court correctly instructed the jury that absence of a broker's license did not bar recovery, submitting the issues of gratuitous service and implied contract under fair and proper instructions. The importance of contract law. Contract law is a significant and pervasive part of our lives. Virtually every personal or business activity involves contract law. Charging a birthday card on a credit card, buying or insuring a car, leasing an apartment, writing a check, paying for college, and purchasing textbooks all involve making contracts. An act as simple as filling the gasoline tank on your car or as complicated as purchasing a house involves contract law. Businesses generally enter into contracts with others to buy the inventory they sell to us and then enter contracts with us when they sell us their inventory. At earlier common law, contracts were not considered that important. For example, Blackstone's Commentaries on the Laws of England, first published in 1756, devoted 380 pages to real property law, but only 28 pages to contracts. Based on its organization, the law of contracts apparently constituted a subdivision of the law of property. Contracts did not merit much attention in that agrarian economy. Contract law increased importance with the rise of a merchant class. Mercantile traditions grew out of the law merchant. The merchant courts were separate from courts of law, and the merchants, or guilds, administered their own rules and customs. Commercial law evolved outside the mainstream of legal development until the end of the 17th century. Contract law continued to develop in the United States. Generally, it is state law, so it varies from state to state. There were very early uniform laws, but their effectiveness was limited. To make state statutes more consistent, the American Law Institute, ALI, and the Uniform Law Commission, ULC, began working on the Uniform Commercial Code, UCC. The UCC viewed commercial transaction as a single subject and attempted to treat all relevant parts of the transaction. The drafters saw that a sale of goods, movable, identifiable, items of personal property, may constitute one facet of a commercial transaction. They also realized that a buyer may use a check for payment for the goods, or that alternatively, the seller may retain a security interest in the goods, a collateral claim against personal property or fixtures. To ensure payment of the debt, consequently, the UCC included articles, chapters or sections on sales, negotiable instruments, checks, drafts, notes, and certificates of deposit, bank deposits and collections, and secured transactions. Article 9, credit arrangements, in which the vendor retains a security interest in certain assets of the debtor. The UCC fulfilled its original goals of 1. Simplifying, clarifying, and modernizing the law of commercial transactions. 2. Permitting the continued expansion of commercial practices through custom, usage, and agreement of the parties. And 3. Making the law uniform among the various jurisdictions. Most states' commercial statutes, with minor variations, include the entire UCC. Louisiana is unique because it has adopted only some of the articles of the UCC. You can access the UCC, including the official comments, at such website. Contract law continues to evolve as more businesses and individuals create contracts online. This evolution poses issues that traditional contract law did not address. Historically, the contracting parties either were face-to-face during their negotiations or communicated by sending signed documents by letter or telegraph. In contrast, the anonymity of online contracting, the virtually instantaneous transmissions of such dealings, and the paperless contracts that result, raises legal concerns. Traditional principles of contract law can adequately address most, but not all, of the issues generated by online activities. business people need to understand the rules of engagement for both types of contracts. The ULC proposed the Uniform Electronic Transactions Act, UETA, which deals with e-commerce and electronic communications. UETA supports all electronic transactions in businesses and governmental sectors. For example, electronic contracts, electronic signatures, and the use of electronic agents for electronic contracting, but does not impose rules on such transactions. UETA will not apply to the parties' transactions unless they agree to use electronic commerce in these dealings. The federal government enacted the Electronic Signatures and Global and National Commerce Act, known as the Federal e-Sign Act, in 2000. This federal law states that no contract, record, or signature may be denied legal effect solely because it is in electronic form. For contracting parties who have agreed to use electronic signatures, the statute makes electronic contracts and signatures as legally valid as hard copy paper ones. The law does exempt from its coverage certain transactions and such as court papers, wills, and health insurance terminations. These federal and state laws make commercial transactions more consistent and predictable from state to state. Uniformity and harmonization are also goals in the global marketplace. For example, the United Nations Convention on Contracts for the International Sale of Goods, CISG, provides coverage for international sales of goods. It is similar to the coverage provided by Article 2 of the UCC for the sale of goods within the United States. The CISG is discussed in some detail in Chapter 15 through 18. CISG may apply to the sale of goods unless the parties agree to subject themselves to some other rule of law. The European Union has issued several directives that cover some e-commerce transactions. The law of contracts affects our most routine activities, and contract law still relies largely on settled common law rules. Many modern-day doctrines stem from judge-made laws or precedents. Contract disputes decided on a daily basis in jurisdictions around the country significantly add to this body of precedents. Consequently, most of the discussion in chapters 9 through 14 centers on common law contract principles that derive from the judgments and decrees of courts. Exhibit 9.1 summarizes the sources of contract law. Definition of contract. Many definitions exist for the word contract. In general, a contract is a legally binding and legally enforceable promise, or set of promises between two or more competent parties. Put another way, a contract is a promise or set of promises for the breach of which the law gives a remedy, or the performance of which the law in some way recognizes as a duty. Most of us intuitively understand what a contract is. Still, situations exist that at first glance may appear to be contracts but are not. Assume that you are a Jonas Brothers fan. The Jonas Brothers are in the United States for a concert tour. You would really like to attend one of their concerts, but you are unable to afford the ticket price. A friend promises you a ticket to the show, and you are elated. You happily accept the friend's offer. 2 days later, your friend calls to tell you he is taking an old flame instead of you. As you hang up, you contemplate suing your friend. After all, you had an agreement and he has broken a promise to you. You think you deserve to collect money damages for the harm you have suffered due to this breach of contract. Does your agreement give rise to a legally enforceable contract? Will a court protect your expectations and award you damages? Probably not. Most courts will view this situation as a breached social obligation, not a breached contractual promise. You occasionally may read of people suing in small claim courts for the expenses incurred in making plans for dates that never occurred because they were stood up. If plaintiffs win their contract actions, and sometimes they do, higher courts generally overturn these decisions on appeal, determining that these situations are not breached contracts. You need to be aware that a court will not consider all agreements to be contracts. Contrast to the earlier situation involving the Jonas Brothers with this scenario. You called a ticket outlet, ordered 2 tickets for the Jonas Brothers concert, and gave your credit card number. When you arrive at the box office days before the concert to pick up your tickets, you learn the outlet has sold them to someone else. Can you successfully sue this time? You probably can, because this situation involves more than a mere social obligation. It appears to have created binding obligations on both sides. If the court agrees, it will find that a contract existed and was breached, and it will award you damages. This illustrates the importance of that part of the definition of a contract that refers to a legally enforceable or legally binding agreement, because it means that not every promise, agreement, or expectation creates a contract. Elements of a contract. The first requirement for a valid contract is an agreement. An agreement consists of an offer and an acceptance of that offer. The law looks at the agreement from the viewpoint of a reasonable person and asks whether such a person would believe that an offer and an acceptance of that offer actually had occurred. Next, the parties must support their agreement with an exchange of consideration, the bargain element of a contract. Third, the parties must have capacity, the legal ability to contract. Fourth, the contract must reflect the genuine assent of each party. The concept of freedom of contract also implies that a contract must be entered into freely and voluntarily. If one party has entered a contract due to fraud or duress, for example, the court may set the contract aside owing to the lack of genuine assent by the disadvantaged party. Fifth, the subject matter of the contract must be legal. The legality of the bargain is questionable. For instance, if the parties have agreed to do something that violates a statute or public policy. Legality was an issue in the classic case for this chapter. The court considered whether Miller was required to be licensed as a business chance broker under the statute. Sixth, some contracts are required to be in a particular form. Oral contracts are generally valid and enforceable, although they are risky due to possible problems proving that the agreement exists and proving its terms. However, some categories of contracts must be evidenced by one or more writings to be legally enforceable by the court. Note: if the parties enter into such an oral contract and each party performs, no one will question the lack of a writing. Such a contract is just not enforceable by the courts. In summary, to be valid, a contract must be 1. Founded on an agreement, that is, an offer and an acceptance. 2. Supported by consideration. 3. Made by parties having the capacity to contract. 4. Based on the genuine assent of each party. 5. Grounded in a legal undertaking. And 6. Expressed in proper form, if applicable. Each of these requirements is discussed in detail in chapters 9 through 14. Exhibit 9.2 on page 216 shows the elements of a contract. Classification of contracts. The law categorizes or distinguishes contracts in various ways. These categories are not always mutually exclusive, so several different terms may apply to the same contract. For example, suppose a restaurant orders produce from its supplier a set of prices, and the supplier promises to deliver on a predetermined schedule. The understanding between these parties falls under several categories of contracts simultaneously. This agreement is an informal, bilateral, valid, and express contract. Formal versus informal contracts. The distinction between formal and informal contracts derives from the method used in creating the contract. In early common law times, the contracting parties generally engaged in certain formalities. Our contracts were called formal contracts. To be valid, for example, a contract had to be under seal. That is, the document had to be closed with wax and imprinted with one seal, normally an insignia or a distinctive mark. Very few contracts were under seal today because most jurisdictions have abolished that requirement for most contracts. Even the definition of under seal has changed. It has generally been replaced with an adhesive waiver or even a signature with a notation that says under seal. The need for ceremonies and formalities to ensure contractual validity has disappeared to a large extent. Perhaps the best-known type of formal contract now is a negotiable instrument, such as the check. Checks must meet certain formal elements in order to qualify for treatment as a check. Informal, or simple contracts are more common today. In these, the emphasis is not on the form or mode of expression, but instead on giving effect to the promises of the parties. Informal contracts do not require the seal, a specific format, or even any type of formality. Such contracts may be either oral or written, and in fact may even be implied by the conduct of the parties. Unilateral versus bilateral contracts. Every contract has at least two contracting parties. The person who makes an offer, called the offeror, generally promises to do something or to pay a certain amount if the person will comply to the offerer's request. The person who receives the offer is called the offeree. If the offerer requests a promise in return, the offer is for a bilateral contract. There will be promises on both sides. However, if the offerer requests an action as acceptance, the offer is for a unilateral contract. There will be a promise only by the offerer, so there will be only a promise on one side. If the offerer promises to pay the offeree $50 for raking the leaves in the offerer's yard, this contract is unilateral. Only one person, the offerer, has promised to do anything. The offeree accepts the offer by performing the request act of raking the leaves. However, the offeree is not obligated to rake the leaves. Many contracts are unilateral because that is what the offerer intends. See Exhibit 9.3 on page 217 for an illustration. The case of Kuhnhofer v. Naperville Community School District 203 illustrates the nature of unilateral contracts. From 1979 to 1988, Larry Koffer worked for the Naperville Community School District No. 203 as a school bus driver. At the end of each school year, Kuhnhofer received a letter from the school district thanking him for the previous year's work and inviting him to return as a driver in the fall. During the summer of 1988, the Naperville Police Department arrested Kuhnhofer for driving under the influence of alcohol. Kuhnhofer's driver's license was suspended for 6 months. When Dr. Michael Kaiser, the school district's assistant superintendent, learned of this suspension, Kaiser informed Kuhnhofer that the district would not hire him as a school bus driver in the fall. Kuhnhofer sued for the breach of contract. The judge ruled that the school district offer constituted a unilateral offer, and Kuhnhofer's suit was not successful. Because an offer of a unilateral contract is accepted by performance, no contract could result between Kuhnhofer and the school district until he commenced performance. Without a valid license, Kuhnhofer would be unable to perform his end of the bargain. Consequently, Kuhnhofer could not accept, and there could be no contract. In contrast, if the offerer requests that the offeree accept the offer by promising to do the requested act, a bilateral contract exists. There are promises on both sides of the agreement. To use the earlier example, assume that the offerer promises to pay the offeree $50 if the offeree will promise to rake the offerer's yard. A bilateral contract occurs when the offeree accepts by making the promise. Note that in the bilateral contract, legal obligations exist as soon as the promises are exchanged. At that point, each party has contractual rights and obligations. In a unilateral contract, there is no contract until the offeree performs the requested act. Some courts will allow the offeree a reasonable time to complete performance if he or she begins to perform and the offerer attempts to revoke the offer before the performance is completed. Another states the beginning of a performance is an implied acceptance of a unilateral offer. Valid, voidable, void, and unenforceable contracts. A valid contract is one that is legally binding and enforceable. There is an agreement and an exchange of consideration, and there are no concerns about capacity, reality of consent, legality, or form. In contrast, a voidable contract is one that may be either affirmed or rejected at the option of one or more of the contracting parties. The law recognizes that certain parties may be disadvantaged in entering contracts. When a party lacks capacity or can show that he or she did not have real voluntary consent to the agreement, that the party is disadvantaged and can elect to disaffirm, avoid the contract. Note that the agreement is valid until it is disaffirmed, avoided, by the disadvantaged party. For example, if Cameron buys a car in the belief that it was driven only 50,000 miles when in actuality it was driven 250,000 miles, the contract may be voidable on the basis of fraud and misrepresentation. If the seller told Cameron that the car only had 50,000 miles, the court is likely to find misrepresentation or fraud. But if Cameron makes a unilateral mistake in assuming that the car had only been driven 50,000 miles, he may have no recourse. However, the contract remains valid and fully enforceable until Cameron disaffirms the agreement. Void agreement may appear to be contracts, but they do not have any legal effect. They never become contracts because they lack one of the essential elements of a contract: offer, acceptance, or consideration. or because the purpose of the alleged contract is illegal. An agreement to murder someone is void. A contract will not enforce this agreement because it lacks the element of legality. An agreement to provide a service is an illegal contract when the provider does not have the necessary license. On the other hand, it is possible to have a seemingly binding contract that will not be given effect in a court of law. Suppose, for example, that the contract involved is one that must be in writing, such as a contract for a sale of goods priced as $500 or more. If this contract is oral, it will be unenforceable. Note that the contract otherwise appears to meet all the criteria of a valid contract, and the parties may well perform the contract to their mutual satisfaction. However, if one of the parties does not perform satisfactorily, the disappointed party will not be successful in court because the contract is unenforceable. Express versus implied in fact contracts. There are two types of true contracts: express contracts and implied in fact contracts. An express contract is one in which the parties set forth their intentions specifically and definitely, either in writing or orally. Most contracts are of this type. An implied in fact contract is one that must be discerned or inferred from the actions or conduct of the parties. Even though the parties should have expressed their intentions more clearly, it is still possible to conclude that a true contract exists. The circumstances indicate that the parties intended to create an agreement by tacit understanding or by the assumption that an agreement exists. The classic case for this chapter involved an implied in fact contract. Generally, there is an implication of a promise to pay for valuable services rendered with the knowledge and approval of the recipient, in the absence of a showing to the contrary. Also, a promise to pay the reasonable value of the service is implied if one performs for another, with the other's knowledge, a useful service of a character that is usually charged for, and the latter expresses no dissent or uses the service. A common example occurs when a patient makes a doctor's appointment and comes to the doctor's office for medical services. The patient requested the services, and the party should realize that the doctor expected payment. Practically speaking, many agreements have express provisions and also include terms that must be discerned from the actions of the parties. Consequently, a given contract may not fall neatly into one or the other of these categories. Executory versus executed contracts. An executory contract is one in which some performance or promise remains unfulfilled by one or more of the parties. For instance, if Natalie agrees to buy a mattress set from John's Classic Furniture, the contract is executory. John still must deliver the mattress set, and Natalie must pay for the set. If Natalie pays for the mattress set prior to delivery, the contract is still executory, even though Natalie has performed her part of the contract. As long as the contract is not fully performed by both parties, it remains executory. An expected contract is one in which all the parties have fully performed all the obligations or promises set out in the agreement. In the last example, when John delivers the mattress set after payment, the contract will be executed. Neither party has any further obligation. The term executed contract has another meaning. It also means a written contract that is signed. For example, the parties meet in the attorney's office and executed the contract on June 5, 2014. The only way to determine the meaning is in context. Quasi-contracts. Quasi-contracts are not really contracts at all. They may also be called constructive contracts or contracts implied in law. Courts use the concept of quasi-contract to prevent the unjust enrichment of one party at the expense of the another. Even though it may be clear that the parties do not actually contract with one another, the law may treat the parties as if they had. Under this theory, the court can create a contract of sorts for the parties despite their wishes and intentions. The Utah Supreme Court stated its law as, to prove the existence of a contract implied in law, a plaintiff must establish the following. 1. The defendant received a benefit. 2. An appreciation or knowledge by the defendant of the benefit. 3. Under circumstance that would make it unjust for the defendant to retain the benefit without paying for it. A quasi-contract is a fiction engineered by a court to create justice between the parties. Some states recognize multiple theories under the category of quasi-contract, for example, quantum merecit. An unjust enrichment may be separate subcategories. A person will not be liable in quasi-contracts every time he or she receives a benefit, Remember that the policy underlying such recoveries is an avoidance of injustice. A person who buys supplies in a mistaken belief that a contract exists, or who incurs foreseeable difficulties and later tries to make the recipient of the services pay for those extra costs of services, will probably not recover on a quasi-contractual basis. Still, remember that courts can, in a given circumstance, make a quasi-contract in order to avoid injustice. Exhibit 9.4 on pages 218 through 219 show the different classifications of contracts. Contemporary case. In this case, a commercial broker claimed that the property owner owed it a commission on a lease it negotiated for a tenant. Stewart Investment Company v. The Meyer Group Limited. Facts. Stewart Investment Company, Stewart, owned a building in Washington, D.C. The Meyer Group, Meyer, was a commercial real estate broker that specialized in negotiating leases for tenants. The Center for Applied Linguistics, CAL, hired Meyer to negotiate its lease with Stewart. As is typical, Stewart paid Meyer a 3% commission on the aggregate value of the lease. Later, CAL selected Meyer to negotiate its next lease. The agreement indicated that CAL would require its landlord to pay Meyer a commission. CAL decided to stay in the building. Meyer sent Stewart a letter stating that if a lease were successfully negotiated, Stewart would pay Meyer the industry standard commission. Meyer sent 3 commission letters. Stewart's managers never returned countersigned copies. William Meyer testified that Stewart provided oral assurance that I'd get paid, not to worry about it. Stewart presented a term sheet that provided that any commission would be negotiated in a separate agreement. Guy Stewart III emailed his brothers that although I don't say so in the letter of intent, we will only pay Meyer's SIC group a 2.5% commission on the renewal. Stewart never communicated this intent to Meyer. Later, Stewart submitted a revised term sheet providing that Meyer shall be paid 2%. The parties continued to exchange draft term sheets, with Stewart offering a 2% commission and Meyer insisting on a 3% commission. Cowell and Stewart entered a new lease that provided that landlord acknowledges that it shall pay any commission or fee due to the broker with respect to this amendment. Meyer and Cowell sent Stewart invoices. Issue. Did the parties have an implied in-fact contract for brokerage fees? Holding, yes. There was an implied in-fact contract for the fees. Reasoning. Excerpts from the opinion of Beckwith, Associate Judge. An implied in-fact contract is a true contract containing all necessary elements of a binding agreement. It differs from other contracts only in that it has not been committed to writing or stated orally in express terms, rather is inferred from the conduct of the parties. In the context of a commission for the broker where there is no written commission agreement, we have required a broker to show 3 things in order to establish the existence of an implied in-fact contract. First, the broker must establish that the services were carried out under such circumstances as to give the recipient reason to understand that the services were rendered for the recipient and not for some other reason. Second, the broker must demonstrate the existence of such circumstances as to put the recipient on notice that the services were not rendered gratuitously. Third, the broker must prove that the services were beneficial to the recipient. We stated that the broker would satisfy the first element of an implied in-fact contract by establishing that the landlord knew that the appellant was a commercial real estate broker who expected fees from the landlord. The record here is full of concrete proof that Stewart Investment Company knew the Meyer Group was a commercial real estate broker. William Meyer repeatedly sent Stewart Investment Company a commission letter spelling that out in plain terms. All the parties contemplated and articulated at various times both orally and in writing that Stewart Investment Company would pay the Myers Group commission. Everyone knew such an arrangement was standard practice in the industry. Turning to the second requirement, Stewart was on notice that the Meyer Group was not rendering to its services gratuitously. Where a party voluntarily does an act or renders a service, he will not be permitted to recover, for the law does not convert an intended gratuity into a legal obligation. William Meyer was asserting he was not volunteering his services, and he expected Stewart to pay him a 3% commission. Guy Stewart III testified that having been a broker himself, he recognized that they don't work for free, and that there would be compensation due for the services and the value rendered. We turn to the third element, whether the services were beneficial to Stewart Investment Company. Stewart misled William Meyer in order to ensure his continued participation for the fear his departure would doom the negotiations. Guy Stewart III bluntly testified that he purposely kept Meyer in the dark about how much Stewart was actually intending to pay him, so that Meyer would not stop working on a deal. Meyer assisted Stewart Investment Company by drafting the proposed lease, acting as an intermediary between Stewart and Cal, instructing the party on standard terms and market rates, and ensuring that both parties secured their ultimate goal of a new 10-year lease. The fact that Stewart had not hired its own broker to handle negotiations on the lease meant that Meyer had to do more work to make the deal happen. Stewart Investment Company breached an implied in-fact agreement. Chapter 10. Offer, Acceptance, and Consideration. Classic Case. In this classic case, Hoffman asked the Wisconsin Supreme Court to apply the concept of promissory estoppel. Red Owl representatives had given Hoffman the impression that he would be permitted to establish and manage a Red Owl grocery store. Hoffman and Red Owl Stores Incorporated. Facts. Joseph Hoffman was interested in buying and operating a Red Owl grocery store. Hoffman had discussed with a number of Red Owl agents, including Edward Lukowitz. Hoffman mentioned that $18,000 was all the capital he had available to invest, and was repeatedly assured that this would be sufficient for him to establish a Red Owl store. In 1960, Hoffman thought it would be a good idea if he bought a small grocery store and operated it in order to gain experience in the grocery business. On the advice of Red Owl agents, Hoffman bought inventory and fixtures of a small grocery store. After 3 months of operating the store, Lukowitz advised Hoffman to sell the store to Hoffman's manager and assured him that Red Owl would find a larger store for him in another town. Lukowitz told Hoffman and his wife that they would have to sell their bakery business and bakery building, and that retaining this property was the only hitch in the entire plan. On November 6, 1961, plaintiffs sold their bakery building for $10,000. Hoffman did not obtain a Red Owl store. Issues. Should the court recognize causes of action based on promissory estoppel? Do the facts in this case make a cause of action for promissory estoppel? Holding. Yes, Wisconsin courts should recognize promissory estoppel. Yes, its use is justified in this case. Reasonings from the excerpts of opinion C.J. Curry. A promise which the promissor should reasonably expect to induce action or forbearance of a definite and substantial character on the part of the promisee, and which does not induce such action or forbearance, is binding if injustice can be avoided only by enforcement of the promise. Prior Wisconsin cases did not adopt the promissory estoppel rule of the restatement. No other possible theory has been presented to or discovered by this court which would permit plaintiffs to recover. Many courts of other jurisdictions have seen fit to adopt the principle of promissory estoppel. The development of the law of promissory estoppel is an attempt by the courts to keep the remedies abreast of increased moral consciousness of honesty and fair representations in all business dealings, because the doctrine of promissory estoppel is one which supplies a needed tool which courts may employ in a proper case to prevent injustice. We endorse and adopt it. The record here discloses a number of promises and assurances given to Hoffman by Lukowitz, which plaintiffs relied and acted upon to their detriment. Foremost were the promises that for the sum of $18,000, Red Owl would establish Hoffman in a store. After Hoffman had sold his grocery store and paid $1,000 on the building lot, the $18,000 was charged to $24,100. Then in November 1961, Hoffman was assured that if the $24,100 figure were increased by $2,000, a deal would go through. Hoffman was induced to sell his grocery store fixtures and inventory in June 1961 on the promise that he would be in his new store by fall. In November, plaintiffs sold their bakery building on the urging of defendants and on the assurance that this was the last step necessary to have the deal with Red Owl to go through. We determined that there was an ample evidence to sustain the jury's verdict with respect to the promissory representations made by Red Owl, Hoffman's reliance thereon, and the exercise of ordinary care, and his fulfillment of the conditions required by Red Owl. Originally, the doctrine of promissory estoppel was invoked as a substitute for consideration rendering a gratuitous promise enforceable as a contract. A promissory estoppel were to be limited to those situations where the promise must be so definite with respect to all details that a contract would result were the promise supported by consideration. Then the defendant's promises to Hoffman would not meet this test. However, Section 90 does not impose the requirement that the promise must be so comprehensive as to meet the requirements of an offer. Rather, the conditions imposed are 1. Was the promise one which the promisor should reasonably expect to induce action or forbearance of a definite or substantial character on the part of the promisee? 2. Did the promise induce such action or forbearance? 3. Can injustice be avoided by the enforcement of the promise? It would be a mistake to regard an action grounded on promissory estoppel as an equivalent of a breach of contract action. It is desirable that fluidity in the application of the concept be maintained. While the first two requirements of promissory estoppel present issues of fact which ordinarily will be resolved by a jury, the third requirement, that the remedy can only be invoked where necessary to avoid injustice, is one that involves a policy decision by the court. Such a policy decision necessarily embraces an element of discretion. We conclude that the injustice would result here if plaintiffs were not granted some relief because of the failure of defendants to keep their promises, which induced plaintiffs to act to their detriment. The agreement. An agreement is the essence of a contract. An agreement is based on a valid offer by the offerer and a valid acceptance by the offeree. Because offer and acceptance are so important, courts closely examine the words and conduct of the parties to determine whether a bona fide offer and acceptance are present. Although the offerer and the offeree can act through their agents, as discussed in chapters 28 through 30, for simplicity we will refer to just the offerer and the offeree. Courts have developed numerous rules for checking the authenticity of the offer and the acceptance. The threshold for contract formation is high. Courts require rather clear-cut statements that the parties are freely and voluntarily entering into a particular agreement. Conversely, under the more relaxed rules found in the Uniform Commercial Code UCC, a court can infer a bona fide offer and acceptance from the conduct of the parties, even if the parties have omitted terms such as price, mode of payment, or mode of delivery. In this chapter, we discuss the reasons for these developments. Mutual assent. The initial phase of contract formation requires the assent of both parties to the agreement. The common law rules for contract formation required the parties to agree to exactly the same terms. There was no agreement without this matching mutual assent, and no contract was formed. However, it must be noted that contracts formed under the governed by the UCC do not require a matching mutual assent. If the courts find that the parties acted like they had a contract, the courts will treat them as if they had a contract. Contracts under Article 2 and 2A of the UCC are discussed in more details in Chapter 15 and 18. The objective theory of contracts. The common law rules assume that there is a freedom of contract, and also the parties have equality of bargaining power. This in turn assumes that the parties have freely and voluntarily consented to the formation of a contract. How do we judge whether the parties have mutually consented to the transaction? Common law rules tell us that the offerer has the right to set the terms of the offer, and to control the method by which the offeree accepts the offer. The offerer must exhibit a clear and present intent to offer, and the offeree must accept a similar clear and present intent to accept. The law applies an objective standard, a standard that is based on what outsiders can observe, not based on what an individual participant thought, to determine whether a valid offer exists. And common law expects a jury or a judge to put itself in the offeree's place to ascertain if a reasonable person would believe that the offerer was making a serious offer. Obviously, this result depends heavily on the facts. Courts may decide that the offerer did not make an offer if he or she clearly was jesting, was overly excited, or was visibly angry. You should be aware of making offers you do not mean, since both common law and UCC principles may hold you to these statements. Offer. An offer involves an indication by a promise or a commitment of one's willingness to do or refrain from doing something in the future. An offer implicitly invites another person to assent to the promise or commitment. An offer has three parts: a clear intent to make a contract, a communication of the proposed terms to the offeree, and reasonably definite terms, setting the parameters of the proposed contract. Clear intention to contract and definitiveness of the offer. Under the common law, an offer must show a clear intention to contract and be definite in all respects. An agreement to agree at some future time, for example, lacks these requirements. Similarly, statements of opinion, statements of intention, and preliminary negotiations do not result in bona fide offers because they lack definitiveness. But reasonable people will differ as to what constitutes a clear, definite offer and what instead involves only preliminary negotiations or dickering. Since these are questions of fact that a judge or jury can later decide, be cautious. If you want to make an offer, be specific in all particulars. Haggling or dickering lacks definitiveness regarding the details of the transactions and your intentions. Consequently, such preliminary negotiations ordinarily are too vague to constitute a valid offer. How a court interprets the words expressed by the parties will control who wins a lawsuit. For example, are the words, I can send you 2 trademark logos at $5,000 per logo, identical in intent to, I offer to sell you 2 trademark logos at $5,000 per logo. Many people would view these statements as virtually identical, but a strict common law interpretation treats only the second statement as a bona fide offer. The law views the first statement as merely a willingness to negotiate or an invitation to negotiate. Advertisements and auctions. The law in general does not treat advertisements as valid offers because they normally lack sufficient specificity to be defined as such. Instead, the law interprets advertisements as invitations to negotiate, asking persons to come into the store and make offers for goods at the prices indicated in the advertisements. Notice that this rule shows a pro-business perspective of the common law. A contrary viewpoint, the advertisements constitute offer assumes that a merchant has an unlimited supply of merchandise. Consequently, the principle that advertisements ordinarily are not offers protects merchants from potential hardships. On some occasions, however, an advertisement, catalog, circular, price list, or price quotation shows sufficient detail for a court to say that it is a valid offer. Normally, courts require a showing that the merchant has placed some limitation on the advertised goods before courts will find that the advertisement constitutes an offer. For example, the merchant may have specified a time limit, such as for 1 day only in the advertisement, or the merchant may have designated a quantity limit, such as a while they last, or to the first 10 customers. In such a situation, the courts are somewhat more likely to find that the advertisement is an offer and not an invitation to deal or to negotiate. Again, courts refer to the objective standard of what a reasonable person would think. Auctions are similar to advertisements in that the seller is not actually the offerer. Although he or she may appear to be offering the good for sale through the auctioneer, in reality the law treats the bidder as the offerer. For a sale to occur, the seller must accept the bid. The seller can even refuse to sell to the highest bidder, unless the auction is publicized as without reserve. In an auction without reserve, the seller must let the goods go to the highest bidder. He or she cannot withdraw the goods if the price bid is too low. Once the auctioneer lets the hammer fall, the seller has accepted the bid, but until this point the bidder can withdraw the offer and avoid the sale. Section 2.328 of the UCC covers these points, which are discussed again in Chapter 16. UCC and e-commerce variations to the common law rules. Despite the common law requirement that an offer be definite in all material or essential terms, you should be aware that the UCC relaxes this common law prerequisite in several significant ways. For instance, UCC 2-204 states that a contract for sale of goods under the Code will not fail for indefiniteness as long as the parties have intended to form a contract and there is a reasonably certain basis for awarding an appropriate remedy. This is so even though one or more of the terms of the agreement may have been left open. In addition, the UCC contains several gap-filling provisions whereby the court can supply the terms, including price, place of delivery, and mode of payment, omitted by the parties. The Code also validates output contracts, contracts that call for the buyer to purchase all the seller's production during the terms of the contract. A requirements contract, contracts in which the seller agrees to provide as much of the product or service as the buyer needs during the contract term, both of which would be too definite under the contract law, because the Code is predicated on the idea that commercial people particular merchants want to deal with each other, it has also eliminated some of the technicalities that impede contract formation under common law. You will learn more about the UCC and its changes it created when you read chapters 15 and 18. Online sellers should take great care to ensure that any offer is clear and conspicuous. The sellers' websites should refer would-be buyers to a link that set up the entire contract, including terms related to remedies, payments, refunds, and returns, privacy policies, dispute resolution mechanisms, and the like. The offer should also clearly indicate how to accept the offer. Ordinarily, the website includes a box stating "I agree" or "I accept the terms of the offer." The customer indicates acceptance of the offer by clicking on the box. Courts generally enforce such click-on agreements, also called click-wrap agreements or click-on licenses, communication of the offer to the offeree. Another requirement for a bona fide offer is that the offerer must communicate the offer to the offeree. Initially, the rule must seem nonsensical. How can a person accept an offer if she or he does not know it exists? Believe it or not, that sometimes happens. Suppose that Jessica is trying to sell a parcel of land, and several prospective buyers have looked at the property. Gerdinder, one of those prospective buyers, writes a letter to Jessica in which he states, "I am willing to pay $80,000 for the property," signs and mails the letter. On the same day, Jessica writes a letter to Gerdinder in which she states, "I am willing to accept $80,000 for the property." Jessica signs her letter and mails it to Gerdinder. It might appear that there is a contract in this situation. However, under common law rules, there is no contract at this time. Each of the two parties is an offerer, communicating an intent to make a contract. Though both parties are offerers on their letters and offerees in the eye of the other party, neither has accepted the offer proposed by the other party. Technically, there is no contract unless and until one of the parties communicates an acceptance of the offer to the other party. Although most offers are made by one person to another, offers made by the general public or to large numbers of people are perfectly legal. A reward such as money for information leading to arrest and conviction of the persons who vandalized an office building represents a good example. Remember that an offer must be communicated to the offeree before it can be accepted. Suppose that Evan provides information that leads to the arrest and conviction of the vandal, but he did so without being aware of the offer of a reward. Under a strict common law application, Evan would not be entitled to the reward that was offered. The common law requires that Evan must have known about the reward and must have intended his act of identifying the vandals as acceptance of that offer. There are court decisions to the contrary, but these decisions are anomalies. Under the rule followed in a majority of jurisdictions, a person who identifies the vandals without knowledge of the reward is not entitled to receive the reward. Exhibit 10.1 summarizes the notes needed for reaching an agreement. Termination of the offer. Assuming that an offer is made, how long will it remain open? Every offer terminates at some point in time. There are 4 methods for terminating an offer: lapse, revocation, rejection, and acceptance. Lapse. Sometimes the offerer will specify in the offer when it will terminate. If so, the passage of time causes the termination or lapse of the offer. For instance, an offer may state, "This offer will remain open for 30 days. If the offeree does not accept within this time, the offer automatically lapses after 30 days. The offerer has no legal duty to communicate the fact that the offer has lapsed to the offeree. After 30 days, the offerer can make the same offer to anyone else." In many cases, the offerer neglects to state a deadline in the offer. In these situations, how long does the offeree have to respond? To avoid lapse, the offeree must accept within a reasonable time. Determination of what constitutes a reasonable time becomes a question of fact that a jury or judge decides. The trier of fact will consider such things as industry conditions, customs, and usages of trade. In volatile commodities markets, an offer may lapse in a matter of seconds. On the other hand, a period of days or weeks may constitute a reasonable time, and the offer involves the sale of a business. To avoid such uncertainties, the offerer should state specifically when the offer lapses. Lapse also may occur by operation of law. Regardless of the wishes of the parties, an offer automatically lapses on the following occurrences: 1. The death or insanity of the offerer or offeree. 2. Supervening illegality of the subject matter of the offer. Or 3. The destruction of the subject matter involved in the offer. In other words, if Susan offers to sell some cattle to Joan, but Susan dies before Joan accepts, the offer automatically lapses. Assume Susan's cattle are in California and Joan's ranch is in Nebraska, and, after the offer, Nebraska passes a statute prohibiting importing cattle from another state. The supervening illegality of the agreement will cause the offer to lapse. If lightning strikes the barn, starting a fire that kills the cattle, the offer also lapses. Communication to Joan is not necessary in any of these situations. Revocation. Another method of terminating an offer is revocation. Under common law, the offerer possesses virtually unlimited rights to revoke an offer at any time before acceptance. The offerer need not use the word revoke as long as the intention to terminate the offer is clear. In general, revocation does not become effective until it is communicated to or received by the offeree. Interestingly, such communication may be effective whether communicated directly or indirectly. Using our earlier example, Susan may state bluntly, "Joan, I revoke my offer to you." Alternatively, Joan may hear that Susan has sold the cattle to Leonard. In either case, an effective revocation has occurred. Usually Susan will be dealing only with Joan, or at most with a few parties. This is not the case with the general offer to the public. If Denise lost her prize Dalmatian and has offered a reward for the return of or information about the dog, Denise can effectively revoke her offer in the same manner or medium in which she has made the original offer. Because it is too burdensome to require Denise to communicate with every possible offeree, public revocation suffices. Public revocation is even effective against a person who has not seen the revocation and who later comes forward with information about the dog. Methods do exist for limiting this power of revocation by offerers in some circumstances. Finally, even as Susan, in our prior example, promises to keep the offer open for a stated time, such a promise does not protect Joan from revocation. However, if Joan takes an option on the cattle, Susan is legally bound to hold the offer open for the agreed-on period of time. An option is a contract to keep an offer open for some agreed-on time period. Joan will have to pay Susan for the option, but once she does, Susan cannot sell the cattle to anyone else during the option period. Selling the cattle to someone else would breach the option contract. Usually Joan is under no obligation to exercise the option. If she does not, Susan can keep the money or other consideration paid to her for the option. If Joan does exercise the option, the money paid for the option may be subtracted from the purchase price. Whether Joan will have a credit for the amount paid will depend on the parties' agreement. Joan may also be able to use promissory estoppel. The equitable doctrine of promissory estoppel can prohibit offerers from revoking their offers. It prohibits a promisor from denying the making of a promise or from escaping the liability for that promise because of the justifiable reliance of the promisee. Under the doctrine, offerers can't be stopped from asserting a defense that would be available to them under common law. For Joan, the offeree, to successfully use this doctrine, she must show that 1. Susan the offerer promised her that Susan would hold the offer open. 2. Joan relied on this promise. 3. Joan consequently suffered a detriment, making Joan pass up the opportunity to purchase other cattle because she thought she would get Susan's. And 4. Injustice can be avoided only by forcing Susan to keep the offer open. In several cases, plaintiffs have used this doctrine successfully to cut off the offerer's power of revocation. However, the rules of promissory estoppel are vague, and it is difficult to predict whether a court will use it to assist a plaintiff. UCC and e-commerce variations to the common law rules. Another exception to the rule that an offerer can revoke an offer at a time before acceptance is based on the firm offer provision of UCC 2-205. An offer by a merchant to buy or sell goods, which is in writing and signed by the merchant, and by which its terms gives assurance that it will be held open, is not revocable, for lack of consideration during the time stated. If no time is stated, it will be held open for a reasonable time. In either situation, the period will not exceed 3 months. The code requires that merchants keep their word even if they have received no consideration for their assurances. Rejection. So far, we have discussed the offerer's power to terminate the offer. The offeree, of course, can refuse the offer and thereby terminate it. The law calls this rejection. Like revocations, rejections are not effective until communicated to or received by the offerer. For example, Joan can reject Susan's offer by telling Susan that she is no longer interested in the cattle. The usual rule holds that an offer cannot be accepted after lapse, revocation, or rejection because the offer has already been terminated. If the parties are still willing to deal, they may form a valid agreement after one of these events. The parties generally are not obligated to continue the transaction unless they agree to do so. Exhibit 10.2 summarizes the various methods for terminating an offer. Acceptance. Acceptance is the usual mode of terminating an offer. This is a significant moment for the offerer and offeree. Bearing problems with consideration, capacity, genuineness of assent, legality, or proper form, a binding contract now exists. Acceptance is the offeree's assent to all the terms of the offer. The offeree's intention to be bound to the total offer must be clear. The offeree's mental reservations will not be binding on the offerer if they are not stated to the offerer. As with offers, courts apply the objective test to see whether the acceptance is valid. Generally, the method of acceptance, that is, oral, written, or implied, through some act such as cashing a check, does not affect its validity. As we will see later in this chapter, there are some exceptions. Mirror image rule. Under common law rules, an acceptance must be clear and unconditional. This concept called the mirror image or matching ribbons rule of common law, which means that the acceptance must match, term by term, each of the provisions in the offer. Any deviation from these terms, whether by alteration, addition, or omission, makes the acceptance invalid and equivalent to a rejection of the original offer. This result follows from the offerer's power to set the terms of the offer and the manner of acceptance. Any deviation from the terms of the offer is a counteroffer. Counteroffers terminate offers by replacing the prior offer with a new counteroffer. The original offeree now becomes the offerer. There will not be an agreement unless the original offerer, now the offeree, is willing to accept the new terms of the counteroffer. The original offerers are not obligated to accept unless they still want to deal. If you desire to enter into a contract with the offerer, you should pay close attention to the language of the acceptance. Mere inquiries, requests, and terms implied by law do not invalidate the acceptance. If Mustafa offers to sell his car to Juanita for $2,000, and Juanita says, "I'll take the car at $2,000 as you offered, but I'd like to throw in the snow tires." A valid acceptance probably exists. Juanita's added statement is a request, not a demand, and would not be treated as a counteroffer. Contrast this with Juanita saying, "I accept if you throw in the snow tires." The latter statement sounds like a requirement or a condition and may be viewed as a counteroffer, making the statement legally ineffective as an acceptance. If Mustafa is willing to let Juanita have the snow tires as part of the deal, he can then accept her counteroffer. UCC and e-commerce variations to the common law rules. UCC 2-207 relaxes common law rules by permitting a contract to arise between the parties even if the offeree adds terms or includes different terms in the purported acceptance. This provision reflects the UCC drafter's knowledge of commercial practices, specifically the fact that buyers and sellers in commercial settings generally exchange their respective forms, that is, purchase order forms or order acknowledgement forms, which may contain contradictory terms. Rather than hamper commercial dealings by applying the common law rule, the UCC drafters permit a contract to arise between the parties unless the offeree expressly has indicated that his or her acceptance of the offer is conditioned on the offerer's assent to these additional or different terms. Section 2-207 of the Code also sets out a scheme for determining the operative terms of the contract in these circumstances. For instance, between merchants, the additional terms automatically become part of the contract without the offerer's consent unless 1. The original offer expressly requires the offeree to accept the terms of the offer, 2. The additional terms materially alter the contract, that is, they would unfairly surprise or be unduly oppressive to the offerer, Or 3. The offeror has notified the offeree that he or she will not accept the new terms. UCC 2-207 states that conduct by both parties that recognizes the existence of a contract is sufficient to establish a contract for sale, even though the writings of the parties otherwise do not establish a contract. You will learn about these concepts in succeeding chapters, but for now, appreciate how the UCC alters the common law rules and the underlying rationales for these changes. Manner and time of acceptance. To create a valid acceptance, the offeree must accept in exactly the mode specified or stipulated by the offeror. So if the offeror says that acceptance must occur by telegram, a letter will not constitute an effective acceptance. Sending a letter in the attempt to accept legally would be viewed as a counteroffer. It is, in effect, a new offer. Similarly, if the offer says acceptance required by return mail, an acceptance placed in the mail 2 days later is invalid. In addition, when the offerer says acceptance effective only when received at our home office, a contract will not arise until the offerer receives the acceptance. Even though the offerer has the right to set the method of acceptance, the offerer may choose not to stipulate the mode necessary for a valid acceptance. In such cases, the offeree can use any reasonable medium of communication, as long as he or she acts within a reasonable time. Usually, the offeree will choose the same medium used by the offerer. By implication, this medium is a reasonable and authorized mode of communication. Consequently, in the absence of a stipulated method of acceptance, if the offerer makes the offer by mail, the offeree's mailing of an acceptance represents a reasonable or authorized mode of acceptance, and thus a valid response. And the other medium, such as the telephone, may be reasonable and therefore authorized as well, if the parties have used in this medium in their prior dealings, or if local or industry custom sanctions it. Use of an authorized mode of communication in either of these circumstances has a particular significance in most states. These acceptances become legally effective at the time of dispatch, mailing, wiring, etc., if the authorized means of communication is used. In order to be legally effective on dispatch, the communication must be properly addressed. If there is a charge to send to the communication, the offeree must pay this fee. This is called the mailbox rule or implied agency rule because the post office or telegraph office is deemed to be the agent of the offerer. Note: the post office is not a true agent, but the use of the post office to send the offer implies that the post office is used for acceptance of the offer. By using the post office, the offeree is complying with the implied terms for accepting the offer. To illustrate, assume that Charlotte did not stipulate this mode of acceptance for an offer that she mailed to Louise, the offeree, on September 28th. Charlotte subsequently attempts to revoke the offer on October 1st, only to learn that Louise mailed his acceptance to her on September 30th. Since the offer was accepted on September 30th, a contract existed as of that date. So Charlotte cannot revoke. An offer can be revoked unilaterally by the offerer. An agreement cannot be revoked unless both parties agree to the revocation. It is irrelevant that Charlotte did not receive the acceptance until after her attempt to revoke the offer. The law treats the post office as Charlotte's agent and concludes that the offerer received the acceptance on September 30th, the date Louise deposited his letter with the post office, because some letters never arrived. It is advisable for the offeree to obtain postal or telegraphic receipts in order to prove the date on which he or she actually dispatched the acceptance. In contrast, where the offeree has used an unauthorized mode of communication, but the exact mode was not specified, the strict rule states that the acceptance is ineffective until the offerer actually receives it. The mailbox rule is not applicable. Even so, some courts will enforce the agreement if the acceptance, even though communicated by an unauthorized mode, is timely, especially if the courts can construe the offerer's language about the proper mode as a mere suggestion rather than a stipulation or condition. UCC 2-2061A, by sanctioning acceptance in a manner and by any medium reasonable in the circumstances, supports these decisions. As you can see, the time of contract formation is crucial. The mailbox rule allows acceptance to occur even before the offerer knows of the acceptance. Such an acceptance cuts off the offerer's right to revoke, because for an attempted revocation to be accepted, it must occur prior to acceptance. Offerers can curtail the effect of the mailbox rule if they stipulate that acceptances will not be effective until received by them. Be aware that the mailbox rule applies only to acceptances. Revocations or rejections generally do not take effect until they are received by the recipient. Consequently, revocations and rejections do not become legally binding upon dispatch, as acceptances sometimes do. Receipt occurs when the communication is deposited or left for the recipient. The recipient cannot prevent receipt by refusing to open the communication. Silence. Acceptance requires a clear intent to accept. Most cases hold that mere silence by the offeree cannot constitute acceptance. However, in some isolated cases, the prior dealings of the parties may permit silence to constitute acceptance. Bilateral versus unilateral contracts. Another major issue regarding acceptance concerns whether the contract, if formed, will be bilateral or unilateral. A bilateral contract is formed when the offerer promises to do something in exchange for a return promised by the offeree. A unilateral contract is formed when only one party promises to do something in exchange for some action or performance by the offeree. The weight of authority holds that an offer that contemplates the making of a bilateral contract may be accepted by either a direct communication of a promise to the offerer or a promise inferred by the offeree's conduct or other circumstances. When the offer contemplates the formation of a unilateral contract, it usually is necessary for the offeree to communicate acceptance. The offeree accepts the offer merely by completing the act required in the offer. Subsequent notice to the offerer would be redundant because the offerer will learn of the acceptance when the offeree requests payment for the services performed. Disputes may arise between the parties as to how much time an offeree has to complete the performance requested in the unilateral offer. Assume Emily says, "I'll pay you $50 to deliver firewood to me." Caleb may think delivery at any time within the next 2 months will constitute a binding acceptance. On the other hand, Emily may get nervous when the firewood is not delivered within 2 weeks, and she may make the same offer to Benjamin, who delivers more quickly. In these circumstances, Emily may not want to pay Caleb for the wood delivered in 2 months later. Emily already has enough wood for the season. Because of such timing problems, courts are somewhat hostile to unilateral contracts and, if possible, will construe such alleged contracts as bilateral. However, the contracting parties can avoid such timing problems by writing down all the pertinent details, delivery date, price, etc., in advance, whether the offerer proposes a bilateral or a unilateral contract. Good planning, even in everyday affairs, helps avoid potential legal difficulties. UCC in e-commerce variations to the common law rules. UCC 2-2011b specifies that unless the parties unambiguously indicate otherwise, an order or other offer to buy goods for prompt or current shipment shall be construed as inviting acceptance either by a prompt promise to ship or by the prompt or current shipment of the goods. This section eliminates many of the distinctions made in the common law between bilateral and unilateral contracts. In the first instance, a bilateral contract is formed. In the second, a unilateral contract. Acceptance is effective in either case. Consideration. The law requires some evidence that parties' agreement is mutual. One way for courts to find this mutuality is by determining that the parties have made an exchange of value. This exchange of value, the quid pro quo of contract formation, is called consideration. This doctrine is essential to modern contract law. Consideration indicates that some obligation or duty worthy of a court's protection generally exists. It also establishes that the parties are acting deliberately and intend to bind themselves to the terms of the agreement. Consideration involves assuming a legal duty or surrendering a legal right at some time in the future. If the assumption or surrender occurred in the past, it will not constitute consideration. Both parties must give up or promise to give up consideration unless the contract is under seal. In a number of states, contracts under seal do not require consideration. Consideration as an act or a forbearance to act. Implicit in consideration is that the parties are promising to do something that they are not legally obligated to do, or that they are promising to refrain from doing something that they are legally permitted to do. It is important to check the parties' language closely. Words that sound like promises actually may be illusory, because the parties really have not committed themselves in any manner. If one party never actually agrees to do anything For example, if Gabriella says, "I will sell you my farm for $80,000 if you feel like it," the promise is illusory and unenforceable because consideration is absent. Consideration is necessary for bilateral contracts and unilateral contracts. However, it may be more difficult to see in unilateral contracts. In unilateral contracts, consideration by one of the parties may be the actual act or forbearance to act in lieu of a promise. In the latter situation, the consideration comes from refraining from engaging in a legal act. For example, suppose your parents promise to send you to Europe for the summer if you will earn straight A's in college this year. If you do, the agreement is supported by consideration and will be enforceable in court. Assuming you live in a state where family members can sue each other for a breach of contract, and assuming that you are willing to risk your family relationships by suing your parents, let us apply the definition of consideration to see why this agreement is enforceable. You waived your right to unlimited leisure time in exchange for your parents' promise. You and your parents bargained the straight A's, so the trip is not a gift to you. You must do something, study more than you might like, or refrain from doing something, twittering, texting friends, or engaging in any leisure activities to earn it. Furthermore, your parents, the promisors, promised a legal detriment to pay for the cost of the trip, while you, the promisee, suffered a legal detriment studying hard all year as a result of this bargain. Your act of making perfect grades has been given in exchange for your parents' promise to pay for your trip abroad. The trip abroad hypothetical illustrates the formation of a unilateral contract. The analysis will be very similar if your parents enter into a bilateral contract with you and you promise to earn straight A's in exchange for your parents' promise to send you to Europe. In this situation, the respective promises constitute the consideration to support the agreement, as long as the promises are genuine and not illusory. You can sue your parents if they do not pay to send you to Europe after you earn straight A's. On the other hand, your parents can probably sue you if you fail to earn straight A's as you promised. Take this example one step further. For instance, if your parents breach a contract and you want to sue them, they may bargain with you to drop the lawsuit. If they promise to pay you $2,000 in exchange for your promise to forgo legal action and you accept this offer, you will have made another enforceable contract. Why? A promise to act or to forbear from a certain action bargained for and given in exchange for another promise constitutes consideration. Therefore, you should be able to convince a court to enforce your parents to pay $2,000. If they change their mind and refuse to do so, you surrendered your right to sue in exchange for their promise to pay you if you do not pursue litigation. Adequacy of consideration. Will your parents win in the earlier example if they agree that the $10,000 they will spend on your trip to Europe is too much, or that you are not really doing anything because becoming an honor student is insufficient detriment to you? Usually your parents will lose because courts generally are unreceptive to such arguments. The classic rule states courts will not inquire into the adequacy of the consideration. Courts instead will assume that the parties are the best judges of the value of their bargain and whether their performances are substantially equivalent. In other words, courts ordinarily will not second-guess the parties after the fact. Exceptions to the general rule that courts will not inquire into the adequacy of the consideration do exist, however. If a court finds evidence of fraud, duress, undue influence, mistake, or other similar circumstances at the time of contract formation, adequacy of consideration may become an issue. Courts in these situations may permit one or more of the litigants to back out of the deal. In some circumstances, the doctrine of unconscionability, under either the common law or the UCC, also can form a basis for overturning bargains when the consideration appears to be grossly inadequate. Remember that courts do not routinely use this rationale to overturn bargains between the parties.